Hi all, Jacob Austin here from QS.Zone and welcome to episode 110 of the Subcontractors Blueprint, the show where subcontractors will learn how to ensure profitability, improve cash flow and grow their business. Today's episode, number 110, is all about the latest UK construction law cases that every subcontractor needs to know about. In a repeat of the feature that I brought you earlier in the year, Spring Case Law Coffee Break, this is this autumn's Case Law Coffee Break, and I'll be bringing you some notable decisions from the past 6 months, that's April to September 2025, featuring some notable decisions from the Technology and Construction Court, the Court of Appeal and even the Supreme Court. We're talking payment disputes, adjudication enforcement, variations, extensions of time, and contract interpretation. And we'll dig in just a moment, but as ever, if you're new to the show, then please do subscribe for more user-friendly advice on all things subcontracting. Now, let's start with a principle that should be music to every subcontractor's ears. Pay now and argue later. The TCC has been hammering home this principle with absolutely no subtlety whatsoever. By way of example, in a case between VMA Services Limited and Project One London Limited, the subcontractor VMA had submitted an application for around about £106,000 and the contractor Project One failed to issue a payment notice or pay less notice in time. Instead, Project One decided to try and launch a true value adjudication to avoid paying up. And the adjudicator sided with VMA, essentially saying, you haven't paid the notified sum yet, so you can't dispute it yet. The TCC then followed up by upholding that decision when it was later enforced, confirming that the court will make an award of the sums due to the responding party, so there was no need for a second adjudication to rubber stamp it. That case reinforces the pay now and argue later principle, reminding everybody that the timely payment, even if there's a dispute, is crucial to keep cash flowing, to keep businesses running. And in short, if you don't issue those required notices, you must pay the notified sum first, before quibbling over the true value. Another similar but different case upheld the same kind of decision between Lap Industries and First Formations Limited, in which Lap had sent an interim application for $120,000 and Formations had failed to serve their notices. Lap won the adjudication, but Formations still didn't pay. And going on to court to enforce the decision, Lap were faced with Formations' defence that said there were multiple contracts that had been awarded, and the adjudicator had effectively decided on more than one dispute, which is a jurisdictional play, to overrule the decision at all. And they also accused the adjudicator of considering information that's outside of either party's arguments. The TCC wasn't having it. The judge found that there was one contract, but the parties had expanded the scope of work over the course of the project, which is quite common in construction. And when it got to the argument of considering information outside of the arguments, the supposedly new issue, which wasn't one of Lap's original arguments themselves, had come from Formations information that they'd put forward in their defence. So in actuality, the adjudicator was more than entitled to consider that. So Formations were forced to pay up. The TCC in doing that re-emphasises that the bar for challenging an adjudicator's decision is high, and they'll enforce adjudicators' decisions in all but exceptional circumstances. So, serve your notices, or be prepared to break out the chequebook. The court isn't there to be a gatekeeper and a general appeal tribunal for adjudicators' decisions, so you absolutely must pay up to an adjudicator's decision. And if you still think you've been wronged, then you can challenge that position later, but not until you've exchanged the money. And I say this as well, this underpins your entitlement. If you don't receive a payment notice when one is due, then you're able to ask your contractor to pay up the full amount of your application, because under the Construction Act, your application then becomes the default payment notice. There's no need for you to represent any further paperwork. You can just ask for the full amount to be paid, and an adjudicator will back that position. Moving on next to variations, and how even side agreements tie back into the main contract. A couple of notable decisions show the importance of clarity when altering scope or settling valuation disputes. First, there's an interesting TCC decision on what counts as a valid variation instruction. In Grain Communications Limited versus Shepherd Groundworks Limited, the issue was whether an email postponing works was a valid variation under a JCT framework work order. The subcontract, which was for groundworks, required variations to be in writing. Here the employer, Grain, sent an email saying essentially, "We'll still plan to do this project, but not until next year, and we'll keep in touch on scheduling." Later, Grain terminated the work order entirely, and the contractor Shepherd claimed for losses, arguing that the postponement email wasn't a proper variation, but a cancellation. The matter was adjudicated on, and the adjudicator first agreed with the contractor, but when it came to the TCC, the judge disagreed. The court found that the email was an effective variation instruction postponing the work, and not a wrongful cancellation. And they said that the contract's variation clause wasn't meant to be read pedantically. Basically, if the requirements, like confirm in writing, are met in substance, then it's a valid variation. The email didn't explicitly label itself variation or use any magic words, but it clearly communicated a change in schedule, and it was written, which was deemed to be enough. The judge pointed out that variation clauses shouldn't be applied overly technically. It's about the effect and the intent of the instruction, not whether it uses the word variation. The email made it evident that the start date was postponed, not cancelled. And by saying, "We still plan to do this project," it effectively says it's not a cancellation. So Shepherd wasn't entitled to treat it as a breach. So that case confirms that an email can amend work and be treated as an instruction if it fulfills the contract's basic requirements, even if it's informally worded. For subcontractors, that could be a silver lining because it means you can rely on clear emails as binding instructions. You still need to be cautious about receiving verbal instructions, but the court here is saying instructions confirmed in writing, be that a letter or a written email, are valid means to trigger a variation. And it shows as well that the courts are willing to imply terms that consider emails as written information and take a common sense view to what the parties originally intended to do, rather than voiding variations on a technicality. Our second variation-related case delves into settlement agreements in ongoing projects, and specifically whether resolving a dispute via a settlement creates a whole new contract or just amends the existing one. And so, between London Eco Homes Limited and Raise Now Ealing Limited, a contractor, Eco Homes, and an employer, Raise Now, had a JCT contract that got into a dispute and signed a settlement agreement to resolve it. The JCT contract allowed adjudication, but the settlement agreement didn't, and it was basically a payment plan for what was owed, referencing the termination of the original contract. When Raise Now didn't pay up, Eco Homes went to adjudication under the original contract's adjudication clause, treating the dispute as under the terms of the settlement agreement. Raise Now objected to this, saying, "Wait, the settlement agreement is a standalone contract with no adjudication clause, so the adjudicator has no jurisdiction." The TCC disagreed with this, and this is a key point. The judge held that the settlement agreement was not a new contract, but a variation of the original contract. Therefore, original adjudication clauses still applied. The court gave several reasons for that. The settlement explicitly referenced the original JCT contract, like the termination provisions and the notices. It preserved rights under the original contract, and had an entire agreement clause that the judge interpreted as referring to the wrapping up of the old contract and not replacing it altogether. Commercially, it made sense. The parties didn't intend to lose the handy adjudication method in their settlement, so Eco Homes could enforce the adjudicator's award. I would also argue, if the judge had wanted to make the statement, if they'd decided it was a new contract altogether, that because they were still doing construction work, the Construction Acts would have implied an adjudication right to that contract, in spite of there not being one written. The right to adjudicate is heavily supported by the courts, most probably because it's seen as quicker, and because it prevents the court from wasting time on little disputes. The courts hate things that waste the court's time. and the judge in his decision referenced a growing judicial emphasis on encouraging alternative dispute resolution. So in plain English, judges want you to adjudicate, to sort things out quickly and without cases crossing their desk. So they'll interpret contracts in a way that keeps that option open wherever it's reasonable to do so. Okay, now it's time to talk about extensions of time and notice clauses. Not the most glamorous topic, but an important one, and one that could save or cost you a fortune. There was an important Court of Appeal decision between the Disclosure and Barring Service, DBS, and Tata Consultancy Services in 2025, which tackled a classic contract clause, the old if X happens, then Y must happen notification provision. Here, Tata was hit with a massive delay claim by the DBS for a late IT project. Tata argued DBS couldn't claim liquidated damages because DBS hadn't issued a required non-conformance report when the milestone slipped. The contract said if milestone X is missed due to a contractor default, the authority, DBS, shall promptly issue an NCR, and then DBS can choose remedies like delayed payments and so on. That sounds like a clear condition precedent. But the trial judge wasn't so sure. On appeal, Lord Justice Colson and colleagues made it clear, yes, it's a condition precedent. The if-then structure was clearly intended to be conditional. DBS had to do step 1, issue the NCR, before step 2, charge delay costs. The Court of Appeal even dissected minutiae like a stray comma in the clause, showing lawyers really will argue about anything. The DBS argued that the comma meant the NCR wasn't actually a part of the condition. But Lord Justice Lewison noted that the comma merely served to break up what was a 13-line sentence. It didn't change the meaning. In other words, don't think punctuation is going to save you from a clear if-then requirement. But there was a wrinkle. The contract said the NCR must be issued promptly, but it didn't give a firm time limit. So does failing to issue a prompt notice void the right or entitlement to delay damages altogether? Well, the Court of Appeal stopped short of that. Lord Justice Lewison mused that if an NCR is issued late, it can still satisfy the condition, saying, until a non-conformance report is given, the clause cannot be relied upon, but once it has been served, it can be. If the NCR was late and that caused further delay, then the contractor might get compensated for that, but the key action is that the notice is eventually served. In the DBS's case, they never served that NCR at all, so they lost out entirely. The court didn't definitively decide if a late notice is as good as a timely one, but it strongly hinted that late compliance is better than none at all. Perhaps to test that, the DBS could have issued an NCR after the case, and really tested how late the notice could have been and still relied on it. That would have made for interesting reading at least. For subcontractors and contractors alike, the big takeaway from this is that you need to read your contract clauses carefully. So if a clause says, if X, you shall do Y, then the courts are likely to enforce it as a strict condition precedent to your rights. For example, if there's a delay, you shall notify the contractor within 7 days. Even though the phrase condition precedent isn't explicitly written, it has that you snooze you lose meaning and implication. Modern courts look at natural meaning and commercial purpose, not formalistic wording, to decide if a notice clause is a prerequisite. In the Tata case, not issuing the NCR cost the client over £100 million in counterclaims. That's massive. So that tells you, if you're a subcontractor and your contract says issue notices for extra time or money, then do it. Do it by the book and do it on time. The same clearly works in reverse. If the contractor has to issue a notice to you before he charges you with delays, then you have a ready-made defence if they haven't issued it properly. This Court of Appeal decision provides fresh guidance on those if and then clauses, effectively saying they'll be treated as binding conditions, so you must follow them precisely. Okay, final topic for today is a Supreme Court ruling that doesn't deal exclusively with subcontractors, but it will have ripple effects throughout the whole industry. This is the case between URS Corporation and BDW Trading Limited. and essentially ruled in May 2025 about liability for defective construction work, and essentially answers who can sue whom for building defects discovered years later. BDW, part of a major developing group, had hired URS as an engineering consultant to design high-rise residential buildings. Years later, some serious structural defects came to light. That sounds like a Brown moment. By that time, BDW had sold the interest in the building to other investors, so BDW technically didn't own them, but it paid to fix the defects themselves. Normally, once you've sold a property, you might think you can't recover repair costs because you have no legal liability to the current owners or residents. And URS, the consultant, argued exactly that. Since BDW wasn't liable under the old Defective Premises Act, which had a 6-year limit that had passed, and no one had sued BDW, that BDW's remediation was voluntary and basically an act that they did out of their own kindness. So URS argued they shouldn't have to pay for it. But BDW countered that they had to do the work because there were significant life safety issues, reputational risks that they weren't willing to take, and later the Building Safety Act 2022 extended the liability period to 30 years, which theoretically put BDW back in the picture for making those repairs. The Supreme Court sided firmly with BDW, the developer, and it dismissed URS's appeal on all 4 of its arguments. And the court made this decision based around 2 big points. Firstly, a professional services company like URS owes a duty of care to its client, the developer, in tort, even if the developer has sold the building and isn't being sued by third parties at the time. URS can't shrug their shoulders and say, well, you fixed it on your own, it's not our problem, because the court noted that BDW still faced real pressure, even without having an active lawsuit, on a moral and safety front, as well as reputational damage at stake, and potential personal injury liability if they ignored the significant defects. So realistically, BDW had no alternative but to remediate the building, and those costs were a foreseeable result of URS's negligent design. Secondly, the court acknowledged the new Building Safety Act's role, even though BDW's claim against URS was around negligence and contribution to a defective end product. The fact that the new Act would extend limitation on defect claims up to 30 years meant that BDW's liability to the new owners would spring back into life. That reinforced that BDW's remedial work wasn't a voluntary act. It was done with the very real and looming shadow of potential liability enforced by the law. So the Supreme Court effectively said, yes, developers can recover defect remediation from consultants even if the developer no longer owns the building at the time of repair, and that the duty of care owed by URS to its client and then the onward building owner may survive, particularly when public safety is the issue. There's another interesting point there, in that the court has found the Defective Premises Act can make consultants liable to developers and not just end users or the buyers of a building. It's not just a one-way street, so if the developer is on the hook to a buyer, the developer should have a corresponding route to sue the responsible party, in this case, the negligent consultant. And here's why this matters to you as a subcontractor. This judgment strengthens the ability of owners and developers of a building to come after the project team for defects, even long after the project finishes. And that could mean claims filtering down the contractual supply chain. So a consultant held liable might turn around and sue a subconsultant or a subcontractor if they contributed to the defect with defective design. It also underscores the huge impact of the Building Safety Act 2022, which extends liabilities and duties retroactively. And the Supreme Court has basically endorsed that approach in principle through making the decision in this case. And that's why this has been called a landmark case. It's certainly a big win for developers, but it probably makes for a big fright for consultants and their insurers, because the duration of their liability has just extended significantly. So the industry takeaway has got to be that quality and safety responsibilities need to be taken absolutely seriously, because they can come back to haunt you decades later. And there we have it. For 6 months worth of construction law, that was pretty eventful, I thought. We've seen courts doubling down on adjudication enforcement, making sure that pay now, argue later is an enforceable reality and not just a slogan. And we've been reminded that if your contract says, jump through this hoop to get your extension of time, then you better get jumping. And do it on time. As well as the whistle-stop walkthrough of the landmark building safety case. Some of the early decisions we mentioned ultimately empower you to enforce your rights, whether that means getting paid what you're owed or having clarity on the use of adjudication when you need it. We've also seen that lawyers are literally willing to argue over the placement of a comma, and probably get paid handsomely for doing it. And with that, I'm going to call it a day on our autumn case law coffee break. I hope you've enjoyed the show today. My mission with the podcast is to help the million SME subcontractors working out there in our industry. If you've taken some value away from today's episode, then I'd love it if you'd share the show and pass that value on to somebody else who'd benefit from hearing it. And of course, subscribe yourself if you haven't already. And thanks for tuning in. If you like what you've heard and you want to learn more, then please do find us at www.qs.zone for more information. Or you can find me on all your favourite socials, again at qs.zone. Thanks. I've been Jacob Austin, and you've been awesome.